I move that a bill for an Act to amend the Misuse of Drugs Act 1981 to make it lawful for an adult to possess small quantities of cannabis for personal use, make it lawful for an adult to cultivate not more than 6 cannabis plants for personal use, permit an adult lawfully in possession of cannabis to give the cannabis by way of a gift to another adult and for related purposes, be introduced and read for a first time. Now, much can be said about the need for parliamentarians to serve and protect the people whom we represent. One example might be the need to address potential harms caused by substances that ought to be properly regulated. We have legislation in this respect regarding medicines, restricted medicines, poisons, harmful agents and illicit drugs. For decades now, governments of both persuasions have almost uniformly subjected the population to a strict ban in relation to cannabis, fearing that this substance may be entirely harmful without any discernible medical benefit. Since legalisation of cannabis for medical purposes alone in 2016, that ban is now clearly without merit. There remains, however, a clear discrepancy in the law whereby the cannabis plant, even if prescribed by a doctor for medical reasons, when grown at home, is unlawful. We are well aware of the widespread use of cannabis as a homemade medication, usually consumed to address either mental health issues, such as anxiety, or physical problems, such as chronic pains. Only last year, I tabled a list of more than 4,000 recent internationally conducted academic studies which consistently demonstrate the clear benefits of both recreational and prescribed cannabis for a wide range of conditions. Close examination of those studies reveal little or no evidence of a meaningful distinction between the two types. These same studies also highlight an absence of enhanced risk of adverse effects when either form of cannabis is used in moderation. The 2021 election brought 2 elected members of Parliament to the Upper House with a mandate to legalise cannabis. Together with the reported 78% of the population supporting at least decriminalisation of cannabis, this suggests a clear and pressing need to review our current legislation. The bill now before the House seeks to place cannabis in a more secure position, appropriate to its social and societal benefits, while also mitigating the possible risks that misuse might cause. The legislation can be broadly broken into 2 areas: easing access to specific amounts of cannabis grown legally within the private premises, and ensuring that the physical and mental safety of minors is protected by excluding them from contact with cannabis, in the same or better ways than children are protected from access to alcohol and tobacco. The details can be outlined as follows. Firstly, on royal assent, it will be legal to possess up to 50 grams of cannabis for personal adult use. This is not an absolutely new provision, as the Gallop government did in fact decriminalise the possession of small amounts of cannabis. Indeed, I note that this is still the official position of the State Labour Party, as evidenced in the most recent 2023 policy document. Recreational use of cannabis has always been part of social structure. Indeed, over half of the population has tried it at some point in time, and about 10% of the population consume cannabis on a regular basis. Use of cannabis has a wide range of definitions, but it is recognised that for regular use, it is abundantly clear that limiting the number of plants to 2 is insufficient. The intent of this bill is to allow for homemade remedies to be prepared with sufficient supply to last for the duration of treatment, thereby greatly reducing the need for the individual to rely on illicit sources. By extension, this reduces the burden on our police force, reduces the criminal element in supplying cannabis, and allows for enhanced attention being paid to those same criminal elements supplying illicit drugs or trafficable quantities. The bill will allow a person to grow up to 6 cannabis plants at an adult's principal place of residence, indoors or outdoors, to share or gift up to 50 grams of cannabis, and to possess and use up to 50 grams of cannabis in private, or the quantity derived from the 6 plants, without an offence being committed. The Legalised Cannabis Party WA entered Parliament in 2021 with an election commitment to deliver this bill. Public support for the intent of the bill has been repeatedly demonstrated. At the same time, however, responsible legislators will also ensure sensible safeguards for public safety and health. The bill demonstrates in the succeeding clauses the measures taken to achieve that aim. Clause 4 amends Section 5 of the Act, which provides for offences relating to premises and utensils used in relation to prohibited drugs and prohibited plants. Under this legislation, a person does not commit a simple offence under subsections of this bill by reason only that the premises are being used for the preparation, use or supply of cannabis or cannabis plants, in circumstances that are lawful under new Part 3A, Division 4, as inserted by the bill. A major need for amendment to the Act rests on the current risks inherent in cultivating a plant that is to be used for recreational and medical purposes without good management of the plant. In medical terms, this can be described as harm minimisation, but in effect, we are implementing safe practice. Hydroponic cultivation, when used correctly, provides a safe outcome for personal use, and this would also now become a lawful act in the new Part 3A, Division 4. Logic dictates that with lawful cultivation of a plant for personal use, often on a regular basis and to mitigate low-level health issues, references to offences regarding drug paraphernalia also need to be amended. Clause 8 inserts new section 7b(8), providing that a person does not commit an offence under several subsections regarding the display, sale or possession of drug paraphernalia in circumstances that are now lawful under new Part 3A, Division 4, as inserted by the bill. It should come as no surprise to members to discover that the Legalised Cannabis Party requires a strong emphasis on safety of minors. Clause 9 and subsequent clauses provide amendments addressing the requirements to ensure the safety of minors. While adults are deemed to have maturity in their personal decisions to use cannabis, minors who are found to be illicitly using cannabis are still liable for management under the cannabis intervention requirement. It is made clear that all of Part 3A, Division 2 of the Act will only apply to young persons and not only Section 8G as it does prior to the amendments. In particular, the bill in Clause 15, inserting the new Section 8MG1, confirms that it is an offence for an adult to smoke cannabis so that a young person is either passively exposed to or actively can smoke or inhale the smoke or fumes of the cannabis. Sensible exclusions also ensure that no injustice is caused under particular conditions. When it comes to gifting cannabis, the bill takes the same approach as that of a beer drinker. Not everyone has the time, skill or inclination to brew their own beer, and a friend might share their output. In like manner, growing cannabis for personal use is not as easy as one might think. The new Section 8MH will make it lawful for an adult to supply or offer to supply cannabis to another adult if the supply is not for payment, reward, consideration, barter exchange or compensation, and the quantity of the cannabis being supplied or offered for supply does not exceed 50 grams. With these same sensible amendments, it would also be lawful for an adult to supply or offer to supply no more than 6 cannabis plants to another adult. In effect, these provisions allow the gifting of cannabis and cannabis plants within the lawful limits for personal use and cultivation under the preceding provisions of the division. Members will recall the efforts to enact legislation recommended by the eminent legal mind of the Honourable Wayne Martin, AC, KC, whose long-awaited amendments still languish on a desk somewhere in the bowels of bureaucracy. Under Section 32A(1), the following additional subsections rectify this situation, something that the Law Society would like to see implemented. Subsection 32A(1)(a) gives a court discretion in relation to the declaration of a person as a drug trafficker in relation to cannabis, if the court is satisfied that it would be clearly unjust to do so, having regard to the circumstances of the commission of the offence and of any other matter the court considers relevant. Subsection 32A(1)(b) requires a court to give reasons if it, because of subsection 32A(1)(a), chooses not to declare a person to be a drug trafficker in relation to cannabis. A new division has been inserted in Part 7, Roman 7, Division 3, Provisions for Misuse of Drugs, Lawful Personal Use of Cannabis, Amendment Act 2024. Now that adult possession and use of cannabis has been defined as lawful under the provisions of the bill, there is need to regulate for an orderly transition. This pertains to the circumstances and requirements for managing a cannabis infringement notice, which might already be in place on the day of the amendments coming into effect in relation to an adult. Any such CIN will cease to be enforced from that date. This reflects the fact that the possession of or use of cannabis or possession of drug paraphernalia for which a CIN was issued would be lawful under the amendments to the Act when they come into effect, and so there will be no public policy benefit in pursuing compliance with a previously issued CIN. Finally, amendments have been made to the schedules determining the court of trial or the presumption of an intent to sell or supply should the legal limits be overstepped and criminal behaviour be recorded. Consideration was given to the nature of the provisions in the context of cannabis, and after due consideration and advice, it was thought more appropriate to determine the quantity of cannabis by weight, not by number of cigarettes. Over the course of 3 years, members on all sides of the House have had the opportunity to listen to the opinions, facts, explanations and scientific data that underpin the rationale for the introduction of this bill. It must surely be abundantly clear to all that there is a groundswell of support for the measures implemented in the amendments. That support comes not only from 4/5 of the citizens of our state, but also from legal offices and societies. I note the record of Hansard from 2002 and my discussions with individual police officers on the beat, and that indeed many of our serving officers agree with the move to legalise cannabis. valiant efforts to protect our society are diluted by efforts to chase down a plant in a failed war against drugs. This bill does more than rectify an almost century-old injustice. It will assist in regulating use of a common and popular nutrient, reduce the influence of the criminal element, permit the thin blue line to focus on far more pressing issues, reduce the extent of alcohol-induced violence, including the vile scourge of domestic violence, reduce the extent of fetal alcohol spectrum disorder, a crisis of national importance, especially amongst the populations in remote and rural areas and indigenous populations. And it will enhance social peace and the rule of law and order. Pursuant to Standing Order 1261, I advise that this bill is not a uniform legislation bill. It does not ratify or give effect to an intergovernmental or multilateral agreement to which the government of the state is a party, nor does this bill, by reason of its subject matter, introduce a uniform scheme or uniform laws throughout the Commonwealth. I commend the bill to the House and I table the explanatory memorandum to the bill.